Welcome to the Legal Services Clinic continuing legal education series of CLEs. Thank you for joining us with us. Now, if you're interested in more of CLEs, you please join our channel so you can get these courses. This particular class is called Domesticating Foreign Judgments, Puerto Rico in Florida. The course description is Navigating Interstate Jurisdiction, Registration of Foreign Judgments in Family Law Cases. In today's mobile era, the transitional workplace has become a hybrid remote environment, allowing individuals to work from anywhere globally. This shift in the workplace, forces of nature such as Hurricane Maria or other reasons, led people to move from Puerto Rico and other states to Florida, bringing about critical legal considerations in child support, child custody, and family law matters. Attorneys Rivera and Attorney Santiago will discuss some legal custody issues and implications of interstate relocation, the Uniform Child Custody Jurisdiction and Enforcement Act, Uniform Interstate Family Support Act, Parental Kidnapping Prevention of Aid, and Registration of Domestication of Foreign Judgments. Our speakers in this series are Judge Gisela Laurent, a judge of the Circuit Court, 9th Judicial District. She was educated at the University of Florida and the University of Florida Law School. She was elected in 2017 to the county court and became a circuit court judge. She is currently the associate administrative judge of the family court, and that is speaker number one. Speaker number two is Marivette Gonzalez Rivera. Marivette Gonzalez is an experienced attorney licensed in Florida and Colorado, and a Florida Supreme Court certified family law mediator. She's admitted to the United States District Court for the Middle District of Florida and is trained in interdisciplinary collaborative law and trauma in Florida and Florida family courts. She holds a Juris Doctor degree from Florida A&M University College of Law and a Bachelor's of Science in Administration of Justice for Criminology certification from Rutgers University, New Brunswick from 2011. She is the managing partner of MGR Law Firm. As an experienced lawyer and managing attorney, she has handled hundreds of simple and complex criminal and family law cases, including family law issues, interstate custody, relocation, time sharing, child support, divorce, alimony, distribution of marital assets, business distribution, and many more. Third speaker is Jose E. Santiago, Esquire. He's an attorney whose legal practice concentrates on family law, also has ample experience in jurisdictional issues arising between states. Jose graduated from the University of Puerto Rico's Law School in December 2013, and in July 2020 he founded his law firm, JSC Law Firm. Jose has assisted his clients since 2013 with jurisdictional issues regarding the interstate removal of children, Parental Kidnapping Prevention Act claims, validating and executing custody, adoption, and divorce decrees from any state in the United States, and managing jurisdictional issues when more than one state claims. These are our panelists, and this is our class.
All right, thank you, everybody. So as Mr. Suarez said, I am Judge Gisela Laurent, and I just want to go over the learning objectives for today. So we are going to learn about UIFSA, the UCCJEA, and the PKPA. But before we go on to learn about the rest of the objectives, let's take the temperature. Who here knows what the UIFSA is? Let me see. Show of hands. Okay. What do you think it is?
I think it has to do with custody and international capacity.
Okay. Anybody else? All right. All right. What about the UCCJEA? Has anybody heard what that is? All right. I see some heads shaking. Okay. Good. Good. What do you think it is?
It's the Uniform Child Custody Jurisdiction Enforcement Act.
All right, good, good. As far as the measurement, I'm seeing. Anybody else have any take on what it might be or what it involves? All right, so we're just filling out the room. And what about the PKPA? Has anybody heard about that before? All right, good, 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 good. All right, so today we're going to be also understanding how Florida handles domestication and registration of child support and custody orders from other states and Puerto Rico. And we're going to be understanding basic guidelines addressing specific concerns with Puerto Rico, including non-adoption of UCCJEA. At the end, we're going to have, if we have time, come back, or you can test yourself to see how much better you know what these terms are and they mean, okay? As in any legal terminology, it's knowing the definitions is so important. So in your outlines, we are going to have the definitions involving the UIFSA, the UCCJEA, the PKPA, and all other terminologies that are important when you're addressing domestication of foreign orders. I'm not going to read them to you now, and you don't need to memorize them, because even I, as a judge, do not have every statute memorized. Believe it or not, when you appear before me, I'm pulling up the statute and I'm reading it as we go along. So in anything that you do and anything that you handle, always look at the statute or the legal definitions when you're addressing that issue, so you completely understand what is completely incorporated in that issue and what is it defined by. Because a simple ordinary term can be expressly defined to be something different. So you got to make sure that you're looking at the legal definition as it's defined in the statute, okay? And so we have the legal terminology in the outline for you, specifically for the UCCJEA, the Parental Kidnapping and Prevention Act. We have some hate convention definitions you want to look at. All right?
And with that being said, one of the important reasons of why you should always look at the definitions in the statute, even for myself, you know, as an attorney, when I first started doing domestications of foreign judgments, I was quickly doing, when you do quick glances, you go to foreign judgments, right? Because that's what we're looking for. However, you got to look at the definitions. Puerto Rico is actually under the out-of-state custody orders, right? So in the definition, state, it includes the District of Columbia and Puerto Rico if you're looking at UIFSA, okay? Foreign country means countries including subdivisions. So in today's presentation, when we make reference to New York cases, to Illinois cases, Tennessee's, it's also inclusive to Puerto Rico. At the end of this presentation, you'll hear from Attorney Santiago from Puerto Rico. Puerto Rico actually doesn't follow the UCCJEA, but we'll get to that later on during this presentation. But let's start with UIFSA, which is the Uniform Interstate Family Support Act. So I'm going to give you a fact pattern, okay? And let's see what you would do as an attorney, right?
We all just love fact patterns.
Yes, and with regards to this, by the way, refer to Chapter 88. That's where you'll find the information on UIFSA, and it has a lot of nuances. I'm going to keep it basic, and I'm going to keep it to this fact pattern, because one fact can change the evaluation on what we're seeing, okay? So, Parent 1 and Parent 2, and you can refer to the slide on your PowerPoint. Parent 1 and Parent 2 and the minor child all live in Puerto Rico, right? Or New York, they live in another state. Parent 1 and minor child moved to Florida, and they've been here for more than 6 months, right? Parent 1 seeks an initial action for child support, right? Because Parent 1 from Puerto Rico is with the child here. The other parent is still in Puerto Rico, right? They've been here for more than 6 months. Where do you file?
Florida,
Why would you say that?
because jurisdiction has been established for the child.
Okay, so that is one of the biggest difference between UIFSA and UCCJEA. And the reason why during this presentation I'm going to keep it to UIFSA, which deals with child support, UCCJEA, which deals with custody, is because sometimes people call me, and it depends if it's a divorce paternity. I'm evaluating for different things. Sometimes, for example, in a paternity case, one state might have jurisdiction to determine paternity, one state might have jurisdiction for child support, and another state might have jurisdiction for custody cases. So it becomes very complicated, and there's a lot of nuances. But for the purposes of this presentation, unlike what we've all learned as attorney, that subject matter jurisdiction is what's most important, UIFSA, that's not the case. It's personal subject matter jurisdiction. So in this case, people sometimes, they hear right off the top 6 months, UCCJEA, it must be Florida. No. For child support, if we're doing this, because I didn't mention whether they were married or not, I'm talking about two parents unconnected to any case, the mother wants child support. It is where the payer lives, okay, the obligor. And this can, you can look and go back and look information on the chapter 55, that's federal law, but that's more for creditors and debtors. But I'm speaking specifically to the Uniform Interstate Family Support Act, okay? However, the answer doesn't stay there. So for that fact pattern, the correct immediate answer would be to file in Puerto Rico.
So
Okay.
always think when it's child support, think follow the money. Where does the wallet live? Okay?
And we're gonna talk more about personal jurisdiction.
Okay. So in personal jurisdiction, like I said, there's in your slide, you're gonna have some important cases. It's always important to read. I love reading case law. It's almost like a hobby because I think it gives you a great foundation to have a wealth of knowledge in your memory bank of things that are important. And we have some cases that you need to know that are seminal to these type of personal jurisdiction issues when you're talking about foreign judgments. And so there's a case in there that shows you that if you're going to impose a financial obligation on a party, you have to have personal jurisdiction, which is important. That's why I say follow the money. Show me the money. Also, you know, the UCCJEA, that is for custody jurisdiction, and that's why you're looking for home state jurisdiction when it's an initial determination, okay? But they don't need personal jurisdiction on you because they know that people move. So once they have an initial custody determination, that court, and we'll talk about this later, will say, we're going to maintain the jurisdiction to enforce our orders, we're going to keep jurisdiction, but the UCCJEA is like say, hey, who starts out with the case? And that's different, that's for custody orders. And the next case that we put on the list for personal jurisdiction is that a binding in effect can only be imposed on those who have been served or notified. And so it's very important that when you give proper service to the parties and proper notice, or all of your hard work can be poured down the drain, and you're going to see some of that in other cases that we're going to present to you throughout the presentation. Okay, so as a judge, one of my favorite words is jurisdiction, and I'll tell you that all the time because it really makes the parties stay in your lane. And as a litigator, that should be one of your favorite words too, because you're going to see in some of these cases throughout this presentation where there's been some almost unnecessary litigation, but it is actually good lawyering where the parties have defeated litigation, won on motions to dismiss because they were like fighting jurisdiction. And so you can really do a good job for your clients by fighting jurisdiction, and that's one of my favorite things is, do you have jurisdiction to go forward, and make sure that you do have jurisdiction to go forward.
I personally have filed motion to dismiss when, for example, one example that I can give and have prevailed is when that fact pattern that I gave, right? Mom and child live in the state of Florida, they filed for here, they've been living here for quite a while, dad still lives out of state. Obviously, dad needs a Florida attorney to help him file a motion to dismiss. So that's where I've come in and filed a motion to dismiss. But now going back to jurisdiction, we just said that that's very important, but UIFSA defines the concept of subject matter jurisdiction, right? It's personal, unless, because there's always, different reasons of different ways to get personal jurisdiction, right? So in your slide, you'll see different ways, and we're going to reference to Chapter 88, right? Section 88.2011. So unlike subject matter jurisdiction, where you can't waive, for purposes of UIFSA, you can consent to jurisdiction. So in that case, right, that I mentioned, that fact pattern, if my client was okay and didn't hire an attorney and was okay with entering the order here, even though they didn't have personal jurisdiction over him, and they didn't even have subject matter jurisdiction, he could have consented to it, okay? So that is one way. So once again, go to the statute and then read. But there is a list, and I've outlined the list on the power presentation. There's consent, resided with the child in Florida is one. There's more to it, because now we're getting into forum and other factors in another section of the statute. The child resides here as a result of the acts of the individual, sex in Florida resulting in the child, asserting parentage in court on putative father registry, and other bases consistent with the Constitution, like anything that we have. Well, not anything, but in a lot of our statute, it always leaves a catch-all, right? So always go to the statute and also reference to case law.
Okay.
And with that being said, in the handout, in the PowerPoint, it refers to registration for enforcement. Because now you're going to know, now that you have an understanding of someone, a basic understanding and where to go to, according to the PowerPoint, then now you're going to want to look at how do you register, right? And I have provided a handout with the specific part of the statute that tells you. The most important is, well, not the most important, but one of the things that is important is certified copies of the final judgment. So often people bring here, and not specific, I'm mentioning Puerto Rico, but it could be any other state, right? Because we're talking about out-of-state orders. You have to get it translated. So if you submit a certified copy to the court, it's in Spanish, the judge is not going to know what to do with it, right? So make sure that you get it translated. And once again, look at that handout that we're going to provide for the registration. It goes in, like, I have it here, but you guys have it as well, but 2 copies, including 1 certified, a sworn statement, and it just lists statutory factors that must be in that petition, right? And we haven't even addressed modification. We're just dealing with registering and enforcing petitions, right? And now we're going to go and talk a little bit more about modifications and jurisdiction.
Yeah. Before we move on, I just want to make an important point. You know, it's not that the judge is being mean or that the judge does not like you when they require that you have a certified translated document. It is what the statute requires. Florida, all documents that are filed must be in English, okay? And I have had parties appear before me and they bring an interpreter and they say, you know, can my interpreter just read this onto the record? No, absolutely not. That does not count. It has to be a certified translated document. Just imagine, you know, for an appellate court to have to come back and have to listen to a recording. That's not how it works. So do yourself a favor. You know, you don't want to make yourself subject to a bar grievance. Look at the statute and see what the statute requires. It has to be a certified translated document that has to be followed, or you're going to be subject to a dismissal. Okay. All right. All right. So we got another hypo for you, and that is okay. And you know these hypos, they're based on true stories. Okay. This is not, we're not making this stuff up. All right. So parent 1 and parent 2 and the minor child all live in the initial order issuing state. So there's been a final judgment. Okay. And parent 2 is ordered to pay monthly child support. Parent 2 then moves to Florida. And parent 2 conveniently stops paying child support. What can you do to enforce the foreign child support order? You have any takers? Oh, you guys are so chatty today. Okay. All right. Well, so the first thing you have to do is we have that checklist, okay? And so what you're going to do, because we already talked about it, you're not going to try to say, well, I remember this great CLE that I attended, and I think I remember the steps. No. You're going to go to the statute and look at all the required steps to register that foreign order, okay? Because you have it. And once you register it, then that judge in that new state can enforce it, okay? That's what you have to do, because if not, you can't, the judge cannot do anything. And you're subjecting yourself to not being able to have it enforced properly, okay? And remember, if you don't have it registered, it's not enforceable. You can't, if you try to enforce it in the state where the party doesn't live at anymore, you really don't have jurisdiction over that party anymore. They're not there any longer. The court may have continuing jurisdiction to enforce its orders, but the party is not there anymore, and so you really want the money. But you don't have access to those accounts. You don't have personal jurisdiction over anymore. So you really want to take that order and bring it, because the main thing you want is to be able to, you know, garnish the money from that person. So you got to take it to where that person lives, register that document, that order, and then be able to do what you need to do to get the money for your client. And like I said, even though the main court, like say for example it was Florida, had continuing exclusive jurisdiction, that is to enforce it, you still want the main goal of being able to get the funds. UIFSA adopts the concept that there should only be one court with exclusive jurisdiction to modify the current order. So just always remember there's a difference between, you know, registering it and having exclusive jurisdiction. Keep those concepts in mind and what is the main goal of what you're doing. You know, are you trying to modify the order, or you need to register it for enforcement purposes?
And for modification purposes, you can register and simultaneously do a modification, but you just have to be careful, right, if you have jurisdiction, right? You don't want to get hit with a motion to dismiss and attorney's fees because you are doing something incorrectly and haven't looked at the statute.
And then also, Chapter 88 really lays out. So when you have a goal, your client's talking to you, look at Chapter 88 and identify what is your goal, and then see what is it you want to do, because that'll, you know, there's so many different things that you can do, that when you're having a forward, you want to make sure that you're doing the right thing and taking the right path.
So one of the ways that you can modify orders, if you succeed in a modification, is if no one lives in the issuing state, and if the respondent still has to be subject to personal jurisdiction, right? So everybody lives here in the state of Florida. So that's one easy way to do it, right? And I'm sorry for using the word easy, because there's more to it, of course. Or consent of the parties, because like I said, you can obtain personal jurisdiction by consent. The tricky part with this is, and I can tell you because me personally, I've done modifications and brought cases and domesticated in Florida, is to watch out for the duration. I'm going to give you an example. Child support, you can enforce it, you can modify it. If you modify, you're using Florida law. You're doing child support guideline worksheets, but duration, guess what? Puerto Rico, for example, is over the age of 18. I'm not licensed in Puerto Rico, but I'm checking that when I bring it here to Florida to enforce it or modify, I'm making sure that the judges, and sometimes you have to educate your judiciary or someone else, right, or even your client, that the duration, yeah, you can use the Florida child support worksheet, right, but you don't change the duration on them. So I always make sure that in my orders I put, you know, Florida has taken full faith and credit, and the child support duration is going to be the same. Even though it's there in the statute, just as a precaution, I like to put it in my orders, in my proposed order for the judges.
Yeah, and all that, on that same point that I wanted to touch on is, make sure you know what you can modify and not modify, because you don't want to take a client and give them an expectation that you're going to do a job that you legally cannot do. There's a case in your materials, specifically Harmon versus Harmon, where the husband wanted to modify his alimony, and he retained the attorney to modify his alimony. As a resolution, the judge says, okay, you know what we're going to do as part of the resolution? We're going to order that the wife, they surrender part of the interest in the marital home. Oh my goodness, we don't have it.
It's because that's equitable distribution.
Yeah, and so they said surrender part of the interest in the marital home. And what the court said in this, what it came down to is, listen, once a court has ordered a division of property rights, you cannot come back after final judgment and redivide property rights. It's non-modifiable after the final judgment. And you would think that's common knowledge, but it's not. And so don't take a case and try to domesticate it and then try to come up with a better idea or better resolution for the modification if things hadn't worked out. And we see that often when you want somebody to refinance and they are not qualified for a refinance. You can't come back and say, okay, well then sell the home, or let's divide this, or you can't redistribute property rights, and so that's the Harmon case.
Yeah, so I guess that's why I got taken back, because it does mention the word alimony, the Harmon, but it's on point when you want to address equitable distribution. If you want to address alimony, it's Suitin versus Suitin, which is in your material. So you can enforce in Florida, but you can't modify in Florida. So alimony orders are non-modifiable in Florida. And Suitin is the case, I'm going to give you the fact pattern real quick, because it's the case where they could have prevented, because maybe they could have consented, but someone didn't want to agree. So they got divorced in Miami in 1998, right? Final judgment in Miami. Sometime, wife moved to Tennessee, and husband's the one that has to pay alimony. So husband wants to go ahead and modify alimony. So he files a modification in Miami, because that's where they got divorced. Served her in Tennessee. She filed a motion to dismiss. The wife prevailed. The reason why she prevailed was because of insufficient service. He didn't plead long-arm jurisdiction. So note to self, even if you have it, right, or you think you have it, plead it when you're serving somebody out of state. Then it gets better. So it gets dismissed. So now husband moves to Tennessee. Everybody's in Tennessee now. He files a petition to have the case heard in Tennessee and files a modification for Tennessee in Tennessee. So what happens is the wife now files another motion to dismiss and says, no, even though everybody lives in Tennessee, you can't modify it because UIFSA does not allow you to, and you can't. And the court agreed, the Court of Appeal agreed. So back to Florida. Everybody in Tennessee, Tennessee can enforce it, but if you're gonna modify it, you gotta do it in Florida. And that's why I said keep the issues separate. When you're doing a divorce case, stick to divorce. When you're doing a paternity case, stick to paternity. When you're doing an alimony case, alimony case. And when you're doing a divorce and you're bringing it for all kinds of things, just break down the issues apart and make sure that you do the right thing. One of the funny things in the commentary, I think it was this case. Yeah, it's a commentary. It's I love this part. It says, one commentator has concluded that UIFSA contains possibly the most cumbersome, redundantly filled, unscholarly, confusing, and poorly written set of civil remedies imaginable. Okay, so that's why we're trying to give you the basics, but once again, go back to the statute if you ever have a case on this.
Yes, and I love saying go back to the statute because we only have 25 minutes for the presentation, and as you can see, we already have like 3 minutes left. There's no way we're going to cover all of this in this time period. And so we just want to point you to where you need to look at when you address an issue, because no matter how many years you've been practicing, you need to go back to the statute, because statutes also change with time. Wordings change, and so you always need to look at the language of the statute when you're making a legal argument to make sure that you're grounded in the right language. All right.
Let's go into home state. I would like to address UCCJEA, right,
Yes.
with the time allotted, because I think that's important, and that comes all the time,
Which is
right?
what with the 1 minute that we have?
Yes.
All right, so
We're going to extend our time.
we have 1 minute.
Let's go and do home state, and we'll keep it very brief. And hopefully this helps you, because I know that while we were doing preparing for this presentation, we had a lot of conversations about what the states can do, jurisdictional. So it's not as easy. By the way, and if it was easy issues, there wouldn't be all these, Court of Appeal cases, right? So don't feel like you're confused. Even the comments reflect that it's confusing. So take it slow. But with regards to UCCJEA, what I want to say with that one, it's unlike UIFSA, so it's not personal subject matter jurisdiction. It's not personal jurisdiction. It is subject. It is all about subject matter jurisdiction. It is the home state of the child that takes priority, and that's where the 6 months that you hear often come from. So it is where a child lives with a parent or a person acting as a parent for at least 6 consecutive months immediately before commencement of a child custody proceeding. The reason why I'm reading that is because I didn't want to get it wrong, because it says, or person acting as a parent. We have included in your material Baker versus Tooney, okay? And that's a 5th District Court of Appeals. That was a putative father. It stands for the reason that a putative father may qualify as a person acting as a parent. This is where the mother tried to argue that he had not adjudicated his rights as a father yet, so he had no standing to argue jurisdiction. And home state, the takeaway from that case is that home state is a priority, and a putative father is considered a person acting as a parent, even though they have not. And there was a set of facts there with regards to the registry, but you might want to take a look at that in your material.
And so then the next thing is the UCCJEA is just for determining the initial action. Once you have determined the initial action, that's it. Then you have continuing exclusive jurisdiction, and that the court that made that initial custody determination keeps the jurisdiction. After that, any other court has to get the original court to surrender jurisdiction. So don't forget that. It's a different standard, and a lot of people get that confused, and you'll see so many cases where after the original jurisdiction or determination has been made, they'll say, okay, well, this is the home state. No, that's not what you do. you have to go back to the order where it was at. Let's say, for example, it's Florida. If everybody moves to Michigan and they've been living in Michigan for 10 years, you don't just now say, well, okay, well, Michigan became the home state. No. There's an order in Florida, and if you want to do something in Michigan, you have to get Florida to surrender jurisdiction. That's what has to happen, okay? And it can happen easily, but you have to make those findings on the record. It has to happen. And normally, you just get a meeting, and the two courts discuss it, and they put it on the record, they make the findings, and it's good. But if you make the wrong determinations, it will get sent back. And it may just get sent back and remanded and say, do it the right way. But it has to be that way.
Okay, one of the ways that, two of the ways that Florida can lose, right, exclusive continuing jurisdiction is if everybody basically lives the state, right, or they don't have significant connection. But here, I want to talk about this before we run out of time, because I know that we ran out of time, but well, I love this. So, but I want to talk about
being on Latin time goes well both ways. You could be late arriving and you could be late finishing.
Okay, great. So we're going to talk about, I want to talk about lich versus lich, right?
Okay, go ahead.
So let's say that you had initial jurisdiction and then everybody moved, and now another state, you've managed to register it and you're good to go, and you even have a basis for modification. Well, Florida may decline to exercise jurisdiction also, refer to statute 61.520, but I'm going to talk about lich because I think it's a pattern that happens a lot, right? And I'm going to go off my head while I look for it. I don't want to misquote it, but basically, there's a final judgment. The final judgment gets entered. Father has majority time sharing. Mother has some time sharing. Mother moves out of state. Forgot what state it was. Mother moves Illinois. So mother moves to Illinois. Now, they both agree in 2000. So they got divorced in final judgment 2016. 2020. They say, temporarily, I'm going to let the child go with mom to Illinois. Now, in 2022, both parents agree that the child can go with mom to Illinois temporarily, right? But now we're in 2022, 2 years later. The child has a medical emergency. Child goes to the hospital. Dad is upset with mom because he wasn't made aware. Mom wants to keep the child because it's been 2 years. Dad says, no, I want my child. Not straight like this, but you're following the fact pattern, right? Because it happens a lot. Dad says, no, 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 I want the child back with me in Florida. So the question is, who has jurisdiction? Because I just told you that Florida could decline, right? If there's factors considered. Child has been there for 2 years with mom. I can tell you that dad prevailed, okay, with that. And I was looking at that. They mentioned about the child was going to therapy in Illinois, has situated, become stable, but the court reversed and remanded for the court trial to find consistent proceedings and look at the evidence, even though, despite the evidence that the child was linked, in Illinois, it was but prior agreement of the parties. So it sent it back to evaluate the factors.
Well, I just want to point out, it's what I just said, right? This is a typical case where even though the child had been in Illinois for 24 months, they didn't do it the right way. And so they were trying to say, oh, now Illinois has become the home state, and that's not the standard, right? Because there was already an initial determination, so they had to follow the procedures for having the UCCJEA conference between the judges. And within that conference, in that statute, there are specific findings that had to be made. So the appellate court said, it may prevail that it's in the best interest of the minor child to stay in Illinois, but not until you do it the right way. When you set it for a UCCJEA conference, you notice the parties, it is recorded, both parties have the opportunity to be heard, all the things are followed. And after the hearing is held, and the judges have the right to hear the evidence, and the parties have the right to present the evidence, and a best interest determination is made, then you can decide whether it's in the best interest of your minor child to remain in Illinois or, you know, in the Florida relinquished jurisdiction. That's not what they did. They just said that they made the findings based on now Illinois is the home state, and that's not appropriate. So just be careful. That's why I say always look at the statute to see what are you doing. That should always be your North Star, is what the statutes state. All right, and with that, we have ended our time, and we've kept you longer than you need to for this credit that you're earning hard to get. And we have the second part of our presentation. So thank you so much for being with us today. We really enjoy and respect your time. Last words?
No, I just wanted to say thank you for being here. We'll continue the next part of the presentation with a very interesting interplay on Puerto Rico and Florida and the Parental Kidnapping Prevention Act. Puerto Rico actually does not follow the UCCJEA, so that's next.
Gracias por su tiempo.
So now we have with us attorney Jose Emmanuel Santiago-Cardona from Puerto Rico. And I want to start by you answering me one question. I look and I Google online, does Puerto Rico follow UCCJEA? And depending on what website I look at, some say yes, some say no. Can you clarify that for us today?
Sure, it's a pleasure to be here. Thank you. So the short answer is no. We don't even have the UCCJEA as a law in Puerto Rico. We just only rely on the Parental Kidnapping Prevention Act, which is just basically the only law that we follow regarding interstate jurisdiction regarding custody, visitation rights, and of course we do follow the child support uniform law regarding child support, but regarding custody we don't have, sadly, the UCCJEA.
Okay, so you guys follow the Parental Kidnapping Act, right?
That is correct. That's the only law that we follow.
Okay. And if I had an order from Florida and I wanted to register or domesticate it in Puerto Rico, how would I go about it?
That's a great question, actually. And I will say sadly also, okay? In Puerto Rico, when you have a final judgment from, for example, Florida, Texas, New York, you have to go to the court and validate it as any other state, okay? Because even though Puerto Rico is not a state from the States, from the United States, we do follow, of course, the full faith and credit, and obviously the laws regarding full faith and credit do apply to us. But when we go to the court, we don't have an expedite process to validate that order. We have to go to the ordinary process. That means that I have to follow Rule 55 of civil procedure, which is just basically me filing a new case, which the other party basically have 30 days to respond, and they have all these defenses that they always raise when they request or when a party requests validation from that order, okay? So it's not an expedite process, as per example, Florida, of what you have told me before. In Florida, it should be an expedite thing. I believe so, but sadly not in Puerto Rico. So I would like to give a few more details about the case that we won at the Supreme Court last year. It is important to stress out, if you notice, Michael, my client, filed and won a case of attorney in custody in Florida in 2019, but it was not until 2023 that he actually had his children back, okay? So as I mentioned, the Rule 55 in Puerto Rico, and I want to talk about that right now, is a challenge right now because attorneys get creative and they just basically use one of the elements that actually Michael's case solved on the Supreme Court, but sadly they are still using that that element to relitigate the case, okay? So instead of having you a faster way of validating a case, our Rule 55, what basically do is just makes a new case, in which basically attorneys just try to relitigate the case again. And so we are not necessarily complying with the full faith and credit, and we are not honoring this process, this fast process that we should be doing regarding validating this order from the states. I mean, custody cases should be moved faster because,
So
I mean, my client. Mhm.
before you proceed, so what you're saying, what you're telling us is that Florida, because we want to understand how both interplay, your client, the father, had custody due to a paternity action in the state of Florida, and he was
Correct.
granted a pickup order in what
Correct.
year?
2019.
And then he brought it to domesticate it in Puerto Rico. Okay, and you represented him, but okay,
Yeah.
so you're telling us we need to understand the interplay with Chapter 55 before we get into the case.
Yeah, so
Okay.
basically, Rule 55, the rule of civil procedure that we use to grant full, fair, and credit, or just basically to validate, and you can say domesticate and validate and enforce any foreign judgment from the states or any other country, okay?
Mhm.
When we do have...
We also use Chapter 55.
Oh, really? Oh, I didn't know that. Nice. So in Chapter 55, Rule 55, when you have a final judgment from the states, you only need to see if 4 elements, basically. One, obviously, basic element is that you have a certified judgment, okay? And the county clerk gave you a certified copy. That's the first thing. You always need a certified copy. And the 3 elements that you have to figure out, I mean, to prove to the court in Puerto Rico is that obviously the due process of law was followed, that the court renders the jurisdiction, that the court rendered the final judgment having subject matter jurisdiction, that's not a hard thing to do. And third, more importantly, that the judgment was not obtained via fraud, okay? So you were not fraudulent. You didn't present any, you didn't force the court to make a decision based on something,
Fraudulent
okay?
information.
Fraudulent information. Now, but here's the key word, okay? The Rule 55, what the court did with our case was precisely to define the fraud element. It says, no. It's not that you lied to the court in Florida, okay? In this case, he didn't lie to the court in Florida, okay? It's not that you present something in Florida and because of that, they grant you the custody of your kids. The fraud that we are pursuing here and that we want to evaluate is a fraud that basically just give the court of Florida subject matter jurisdiction, in which case, subject matter jurisdiction that they didn't have, okay? Or I'll give you an example of that. Or 2, that you lie about the fact that she was properly served, for example, okay?
So they're arguing in essence that Florida at the initial action didn't have subject matter jurisdiction. And then secondly, that there was no due process, right? There's due process
Correct.
violations because she wasn't properly served.
Correct. So it's basically the element of fraud, the fraud element, okay, fraudulent element, is just to show when you present fraudulent evidence, okay, or fraudulent information, it's just to give the court subject matter jurisdiction in which actually it didn't have it, okay, or because of any law it didn't have it, or it have subject matter personal jurisdiction over the party when actually you never notify her properly, okay? But what the Supreme Court basically says is that you're presenting something in Florida that you didn't like, okay, that the other party didn't like, is not a cause for us to say we will not grant full, fair, and credit, okay?
I'll give you an example. And you mean by didn't like was that the mother didn't like that the dad granted custody?
Correct. I'll give you a basic example. In Puerto Rico, mom was arguing 2 things. She said, I was not properly served, which I'll speak about that a few months later.
So she objected to domestication, right? So that's
she completely objected. She completely objected. And not only she completely objected, she basically did the following thing. I was not properly served, which is the Supreme Court say, yeah, you were properly served. Okay, of course, I'll give you the elements right now, what happened there. But the most important thing is that, the judgment was obtained because Michael, my client, presented fraudulent evidence, okay? Because he didn't say, for example, that we have, according to her, that we have some domestic violence issues, or that he was not a great father, or that he deprived me of money, okay? Those were the things that she was arguing, okay? So So basically what she was saying, if you say that to the court, okay, in Florida, it was probable that they will not grant you the custody, okay? Problem with that is that in Puerto Rico, once we have a final judgment from Florida, we cannot go to the elements of why Florida granted the custody to my client, okay? The only thing that we will see is that if she was properly served, yes. Did the court have subject matter jurisdiction? Yes. My client didn't lie about that. For example, one of the things that they can say, and they would show fraudulent evidence, okay, fraudulent information. It was, let's say that my client say, oh, my kids have been living in Florida for the past 6 months, which will just grant Florida subject matter jurisdiction. Let's say that he lied about that. Then that specific element will be the one that say in Puerto Rico, oh, you actually didn't present full evidence to the court in Florida, and your lie granted subject matter jurisdiction to Florida, which at the beginning it didn't have. Florida did have subject matter jurisdiction. That was completely clear, okay? That was completely clear, and we know that. And two, that she was properly served, okay? What the Supreme Court say, okay, if those two elements are met and the person didn't present any fraudulent information or fraudulent testimony or whatever, okay, we cannot relitigate the case again in Puerto Rico. And that's what she was trying to do. Okay. I'll give an example. She presented evidence that he was not a great father, that he didn't. I don't know. She made a lot of allegations that he controls the money they were not married, but in the partnership he controlled the money. That's obviously those were just mere allegations because she didn't prove any of it. But she was trying to basically do a mini trial or retrial the fact that the whole case in Puerto Rico, basically just saying, oh, Puerto Rico, don't honor this because if he presented all this evidence and all this allegation with 100% certainty, I will be the one having the custody. And that's what the Supreme Court say. You cannot do that in Puerto Rico. If you want to present those evidence, you had your chance in Florida or go back to Florida, okay? And present your case there, but don't try to escape Florida, move back to Puerto Rico, and then try to relitigate the matter because we will not honor that, okay? We will not do that, okay? In this case, she was properly served, and here's the curious thing. She was served in Florida. She was not even served in Puerto Rico. Mm-hmm. But when she was served in Florida, she just picked up a plane and moved back to Puerto Rico without my client's knowledge, okay? And without even the court knowing what actually happened, okay? So when the court continued notifying her, they notified her on her last known address, which was where she was properly served, okay? But she tried to use that in Puerto Rico, basically stating that I was not properly served of the final judgment because Michael, my client, had a suspicion that I was in Puerto Rico. And the Supreme Court said, no. The burden of proof, okay, to show that you were not properly served cannot be in your hands, okay? It cannot be something that you actually provoke, okay? In this case, if you wanted to actually properly be notified, you had the obligation to say to Florida, I've moved back to Puerto Rico and this is my new address, okay? So when the Supreme Court evaluated, say, no. If you got properly served, it was your responsibility to notify the court in Florida when you moved, not my client, responsibility to actually just wander around where she was.
So was she alleging that she moved, he knew, so that she wasn't properly served at some time, it sounds like? Like it was his responsibility to notify the court. Did he notify the court? Like, did he know that she?
So this actually what happened, okay? When she was served, personally served, even she wasn't even served by the sheriff, okay? So my client hired the sheriff to do this service, okay? To render the process. When she got served and she received the paper, she didn't deny it, okay? She went back to Puerto Rico, and my client did receive a child support document from Puerto Rico. So when he went to trial in Florida, he did say these words: I believe she is in Puerto Rico. But he didn't knew, okay? He didn't knew where she was. And that's what the Supreme Court in Puerto Rico say. You cannot put the burden of proof to Michael's, in this case, Michael, because the responsibility of notifying where you were, if you wanted to be notified about this case, do something extra, do something else, okay? Because now you cannot say, oh, this judgment doesn't apply to me because I was not properly served, when you were the one that actually moved to Puerto Rico, didn't notify Florida, and only notify Florida when you actually received the final judgment, okay? Basically stating, I was not properly served, okay?
So, Attorney Jose, I remember reading something on the dissenting opinion regarding domestic violence, that's one of the reasons that her address wasn't revealed or was confidential or something like that, but I don't want to misspeak. So can you talk to a little bit with regards to that aspect?
Okay, so I think I mentioned that the case was confidential. The case on the first instance court is completely confidential, but the opinion of the Supreme Court is not. So basically, if you go to the decisions of the Supreme Court of Puerto Rico, you can actually find the case and just use the numbers, the citation numbers that we have.
So they can see what we're speaking about.
Correct.
Okay,
Yeah,
so I think
completely.
I have it up. It's Poder Judicial de Puerto Rico. And if anybody
That is
has any
completely
questions, they can shoot me an email if they
Yeah.
want to know where to find this case online in the Puerto Rico, Florida Supreme Court. But anyway,
Correct.
so can you talk to with regards to that part? And I know it's just a dissenting opinion, but that was one of the arguments that were made.
And that's a key word here. So remember when I mentioned that Rule 55 say that if you present a fraudulent case, okay, we will not honor and we will not grant full faith and credit. But she was actually using that alleged domestic violence, which actually didn't exist, okay? But she was using those allegations to basically say, don't honor the judgment from Florida. Because if the judge of Florida knew about this alleged domestic violence, it is probable that the case was granted in my favor, okay? So yeah, she did mention that. The problem with the dissenting opinion is that it is not supported by any evidence whatsoever, okay? Those were mere allegations. In Puerto Rico, I don't know if it happens in Florida, but in Puerto Rico, anything that you say on a motion is just allegations, okay? The judge will not make it.
I think that's how it should be, right? Our judicial
It should always
system
be like that, okay?
in Puerto
Like it
Rico and
doesn't matter, okay?
Florida.
I'll give you one example. When she was served and she moved back to Florida, she didn't tell my client nor the court of Florida, knowing that she was properly served and knowing that she was being sued in Florida. Okay, so she knew that the case was trialing and that the case was pending in Florida, but never notifying anyone. Okay. When my client won the case, when he received the final judgment, he did receive the pickup order. Okay, and he texted her, "Hey, I have won the case. They had granted the custody of my kids, and I have a pickup order going back to Puerto Rico to pick them up," okay? That's when she filed a restraining order in Puerto Rico, which actually was not even granted, okay? Because when the court in Puerto Rico say, "But what happened here?" She say, "Oh no, my ex-partner sent me this text message." The judge in Puerto Rico say, "I'm sorry, but I cannot do that, okay? Okay, because I have to respect what the Florida court already did, okay? This judge actually understand what was happening, okay? So not even ex parte judge order was granted to her. In Puerto Rico, you can go to any court and you say a few mere allegations, and they will grant you an ex parte order, okay? But that didn't even happen to her, okay? Because actually they didn't believe her.
Okay, so the evidence and the testimony, whatever she presented was incredible. So the injunction was denied. Okay.
Correct.
Yeah. So then that means you prevailed and he did get custody of the kids?
Funny part, I did prevail in first instance court.
Because it took years to get to this, even though
I know.
I hope whoever's listening to me, this is it seems
was 4
kind of
years.
insane and frustrating that you get granted in Florida a pickup order and then you have to go through all this once you get to Puerto Rico.
So here's the thing. We did prevail in first instance court, okay? She went to the Court of Appeal, and the Court of Appeal say, oh, she was not properly served. So we lose on court in the Court of Appeal, okay?
Oh, okay.
Yeah. So the Court of Appeal say, no, she was not properly served because my client, even if he had a suspicion, he should have done something extra to serve her. Not to
So they
serve
put
her,
a burden on
to
him.
put the burden on him. Like, hey, it was your responsibility to find another address. And I even reconsider saying, wait a minute, what are you talking about? This lady was the case was even judgment by default. She was on default. She didn't even respond to the complaint. Even though she received a complaint, she never responded to it. So when we lose on the Court of Appeal, I told my client, we only have one shot of going to the Supreme Court. And in Puerto Rico, I mean, I believe the same happened in Florida. Of 90 cases that you send to the Supreme Court, perhaps only one is completely accepted. So we actually were very lucky, and the court did understand what we were trying to say. They say, no, we need to solve this. And basically that's what they say. She was properly served. It was not his burden, it was hers.
Okay, so can you talk a little bit more about the key points and the key differences between the Parental Kidnapping Act and UCCJEA and the interplay in Puerto Rico? Can you speak to that?
Sure. Okay, so as stated before, sadly, we don't have the UCCJEA in Puerto Rico. So that means that we only rely on the parental kidnapping. And obviously that poses great challenges. Because even though the parental kidnapping and the UCCJEA is just basically trying to establish this initial custody jurisdiction or determination, in my experience, the UCCJEA, even though I don't know anything about it, I just only read about it and I have seen it over the cases that I have in trial, grants you more flexibility, okay? And it's completely more, it goes directly to the facts that you need to present to the court in order for the court to say, okay, I have jurisdiction. I'll give you a few pointers, okay? One of the things that I do like about the UCCJEA and not for the Parental Kidnapping Prevention Act is the emergency custody jurisdiction. In Puerto Rico, to grant any temporary emergency custody jurisdiction, we don't have that, okay? We do have, of course, under Law 57, which is basically an amendment of Law 246, we can request a restraining order, okay, for the child, okay? Let's say, oh, this child is here, has been abandoned. I can grant you that order, but that doesn't necessarily mean that I have been doing an initial custody determination. On the UCCJEA, you actually can request a temporary emergency custody jurisdiction. The parental kidnapping doesn't allow you to do that. You can actually use the emergency custody, the emergency custody only and only if there is no home state and there are no significant connections, okay? You cannot bypass those two steps before you actually have an emergency custody determination, okay? So for me,
is the home state the 6 months? How do you define
it? It is 6 months. Yeah. It just basically where the child have been living with a contestant for the past 6 months. That's it, okay? It is basically the same. I believe it is basically the same definition. So homestead is defined as usual.
Okay.
The problem is the flexibility. I'll give you another example. For example, one of the things that I do like about the UCCJEA is the duty of communicating with other states. Okay, let's say that a judge received an order from Puerto Rico, from Kansas, I don't know, and he says, okay, I'll just pick up the phone and call the other attorney or the other judge. In Puerto Rico, even though we have some judges that do it on a voluntary basis, they're not obligated to, okay? In Michael's case, I do remember that I talked to the judge and say, hey, just call the judge in Florida. I say, I don't have to, okay? Which, and actually he's right. He doesn't have to call the other lawyer, the other judge. But if we do have that legislation here, you can actually make more flexible the fact that it will be even way faster for the judge to call the other judge. Hey, judge, what is happening here? Like I say, I do have some cases. I did trial a case in Texas, And the judge of Puerto Rico did call the judge in Texas, okay?
Yeah.
But that's not the norm. It's just only a voluntary thing that they do just to clarify things, but they're not obligated to. The other thing that I do love about the UCCJEA, and not what the PKPA say, is the elements that you have to consider for a state to relinquish jurisdiction, because it says I'm not the most convenient forum, okay? I'm not the proper state. In Puerto Rico, we don't have those elements. So even though a judge in Puerto Rico can say, no, I have the kid for 6 months, I don't care about anything else, okay? So that means that I will have a case in Puerto Rico. Vis-a-vis, if you compare that with UCCJEA, you can actually say, oh, even though I'm the home state, I have these other elements that say I'm maybe not the proper venue to trial this custody case. Go back to Puerto Rico, okay? Or go back to the other state. We don't have that in Puerto Rico. We just only have the 6 month period, and that's it. Once you comply with the 6 month period, we will have a custody trial, okay? So that flexibility, I mean,
To
for
you,
me,
is
that's
a big difference. I don't practice in Puerto Rico, so I
it
don't know
is.
how that works.
Yeah.
So for you, I guess you're a proponent that Puerto Rico has something similar to, or adopt the UCCJEA.
It is funny because we have a new civil code after 90 years, okay? The last revision of the civil code was in 1930. So in 1920, we have a new civil code finally. And regarding the emergency custody jurisdiction, we only have one article. That's it, okay?
That's it?
And it basically says we can have some emergency determinations, but we will honor what other states do, okay? I have tried twice in 2 cases in Puerto Rico to activate for the judge to apply what the new article of the civil code says, and they say no. I don't want to go there. If the other state have jurisdiction, I would not deal with that, and they basically just reject going there.
So let's I think we have a few minutes left for this CLE. So is there any basic tips or anything that we should know that you would leave us with?
Yes, I will say that I mean, for these recommendations for attorneys for actually people that move back to Puerto Rico or they move to Puerto Rico, be aware of that since we don't have the UCCJEA and we do have the Parental Kidnapping Prevention Act, that the 6 months requirement for establishing home state are very strict. In Puerto Rico, if you comply with the 6 months, we will have jurisdiction. And convincing a judge in Puerto Rico to relinquish jurisdiction because other proper venue is way proper, okay? It's actually hard because they don't have any elements to navigating or even decide why other venues should just take other state. Not venue, other state should have jurisdiction. Okay, I'll give you a basic example. Let's say that you have been living all your life in California. You move to Puerto Rico for 7 months. We will have do we actually have jurisdiction for a custody case? The answer is yes. Are we the proper venue? That's another issue, okay? So because we don't have that guidelines, be aware of that, okay? Be aware of, and now in Puerto Rico, a lot of people from the mainland are moving to Puerto Rico for tax purposes and stuff like that, and they have to be aware of that, okay? Also, I will say that even though we do have, and we are obligated for the, because of the federal constitution to grant full faith and credit, be aware that the process to validate and to domesticate that order from another state is not that fast, okay, as we would like to, okay? I have seen other attorneys do even injunctions, okay, to try to speed things up in Puerto Rico. But actually the proper way of domesticating an order from other state is not an injunction. It's actually going through Rule 55 or civil procedure, okay? And for me, the most important thing is an emergency custody determination or an emergency custody jurisdiction. In case of an emergency, I mean, of course, if you're in Puerto Rico, you're in Puerto Rico, file here for emergency custody jurisdiction. But trying to mingle that emergency custody jurisdiction with the 6-month requirement, it's going to be a little bit hard, okay? Because for us to make an initial custody determination, we will first see if we have the 6 months requirement, okay? And if the judge detects that other place or other state is the home state, yeah, they can make perhaps some temporary orders, or they just can actually dismiss the case completely. Say, no, 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 don't bring me this here. Go back to the States and deal with that, okay? Here in family law in Puerto Rico, the lawyers that we deal with this jurisdiction, what basically we do, we just play with the jurisdiction. If you want to trial a case in Puerto Rico, be here and travel here for 6 months. Or if you don't want to do that, just stay in your state. And we basically deal and we play with that jurisdiction, okay?
Okay. So, all right. So I think that jurisdictional issues, no matter where you are, UCCJEA, and we didn't even talk about asume and child support in Puerto Rico, which is just a whole nother CLE in its own, right? Because yeah, and I see it by I see it by your nodding your head.
Actually, it's actually way funnier because in Puerto Rico, asume, which is the child support service in Puerto Rico, they actually are more prone to dismiss cases because of that. If we have an order from another state, we don't want to see it. Okay,
Okay.
It's funny. I know. It doesn't make any sense.
Well,
But
it's funny, but it's not. But it's just like the intricacies of the system.
correct.
But at the same time, it could be very frustrating because, and like I said, we're running out of time. But even when the hurricane, I know that I had to quickly educate myself with the Puerto Rico system when you dealt with Hurricane Maria and just natural disasters and petitions for aunts and uncles in Florida that were trying to help out the family with the kids. But anyway, so I am going to put your information and provide the information for whoever wants to contact you. But this is attorney Jose Santiago, Manuel Santiago-Cardona in Puerto Rico. And now hopefully we have somebody that we can connect when we have jurisdictional issues. But for those viewing it, although we have spoken about it, you need to read the statutes, the parental, and you need to read the UCCJEA, the UIFSA, the Parental Kidnapping Act, be familiar with Chapter 55. This is just a basic understanding. And like always, speak to an attorney, right? That handles cases in that area. But thank you so much.
You're welcome.
For being here with us.
Thank you. It's been a pleasure. Thank you.